Science. I'm Duncan Sandlin. I wanted to do a quick video right now just to test it out. This is the first time we're going live, so if everything goes to hell, you know why. Anyway, we want to talk about the Supreme Court taking up Trump's immunity case. Wanted to wait a few days to try to get a better sense of what's going on with it, but I have a couple clips for you just to kind of get a sense of what's happening. So, essentially what happened is Trump filed an appeal for immunity, for criminal immunity, saying that as a former president, he was immune from things he did when he was president. Now, this went to an appeals case after Jack Smith, who's the special prosecutor, wanted the Supreme Court to take it up. The Supreme Court said no. It went to an appeal. The appeals court shot it down. A 3-0 decision. Wrote a really wonderful, bulletproof reason why presidents are not immune from criminal prosecution. And then Trump appealed it to the Supreme Court. The Supreme Court decided, oh, okay, well, now we'll take it up. And this, of course, now delays his trials. So the question was, did they actually hand him a win here? Now, we're going to go into this. Brian Tyler Cohen is going to talk a little bit about this. Now, this is a few days ago, so he doesn't know everything yet, but this is kind of what the initial response was, just so you guys get a sense of it.
You're watching the legal breakdown. So Glenn, we've got a really consequential update from the Supreme Court with regard to Trump's immunity case. Can you speak about this announcement?
So we just learned that the Supreme Court will grant review of Donald Trump's baseless claim that he has absolute immunity against prosecution for crimes he committed while in office. So the way I would summarize what this means is it means the Supreme Court has just sold American democracy down the river. Here's why I say that's my take on what is now happening. The Supreme Court, first of all, should have rejected this case for review because, Brian, there is not one iota of support for the assertion that a president can commit all the crimes he wants in violation of our nation's laws against the American people and enjoy absolute immunity against being prosecuted, being held accountable for those crimes. Not one shred of legal support.
And, you know, he's not wrong about that. There really isn't any grounds for this case. I mean, should a president be immune? Well, no. The whole point of this country is we have no king. Nobody's immune from the law. We all are subject to the law. But the problem is did they hand him a win here? Because what ends up happening is, and this is kind of what he's going to get into a little bit, which is if they hear this, they're not going to hear it till the end of April, is when they've scheduled it, April 22nd. And so it's the last week they're in session. So they'll hear it that month. Well, that delays the federal case with Judge Chutkan, the January 6th case. Now, if that's delayed, she's also gave whatever is 80 days for them to respond and for his attorneys to be able to prep for it. So let's say it gets decided, probably won't be decided, there won't be a judgment until June from the Supreme Court. Now, what'll they come up with? I don't know. My guess is they will say, no, he's not immune, or immunity only applies to certain things, and we'll get into that in a second. But then she can go to trial, but she's got to rush it, which means they probably won't get to trial till September. Now, if that's the case, then Trump will be in court September, October, maybe even November, probably through the election. Now, you can say, yeah, well, you basically delayed this to the point where he probably won't be convicted before the election, so you gave him a huge win. You could argue that. I would argue the other side of the coin, he is going to court on the March 25th in New York for the fraud trial, for criminal fraud. So by the summer, he could be convicted. Granted, it'd be a state conviction, not a federal conviction, but still, it would be a felony convictions in a state of fraud, and he could be looking at prison time. I mean, he could be in prison before the election. So I don't know that bails him out too much on that sense. What it does do is it delays the federal case. It doesn't necessarily delay the case, Judge Cannon's case in Florida, which is the stolen documents case, where he hid the documents in his, in Mar-a-Lago in his house, and he hid them in the bathroom and under the stage and in a secret closet and all this shit. That case doesn't affected by this because he wasn't president when he did those things. So Glenn makes a good point. It does delay it. It does look like a big win. Now, granted, Glenn didn't know all the facts. This was 3 or 4 days ago that they were doing this. Glenn and Brian were. But I want to go into this. So this is Lawrence Tribe, and he's talking about it too on Lawrence O'Donnell. And Lawrence Tribe has an interesting take, and it's kind of the same one. And I'm going to give you both sides of this to give you sort of the optimistic and pessimistic sort of side, whatever side you're on, just so you can get a sense of what the concepts are, what the arguments are, and what might be happening. So we're going to go into this. Lawrence Tribe and Lawrence O'Donnell. And Lawrence Tribe is a really famous federal lawyer, and he's going to talk about this a little bit more.
Professor Tribe, so glad to have you here tonight on this important night. What is your reaction to the Supreme Court deciding to hear this case?
Well, I was quite convinced, given how long they were taking, that they were likely to decide to hear it. What I didn't know, and what is very disappointing, is that they would formulate the question presented at a level of enormous abstraction so that the delay that we've already seen may just be the beginning. That is, the question presented is now whether and to what extent does a president have immunity after he leaves office from criminal prosecution for conduct alleged to involve official acts during his tenure. Well, of course, Donald Trump alleges that everything was an official act. Jack Smith is at the opposite end. Instead of that,
So I'm going to get this because he makes a really good point there. So the way this is written, I'll read it for you. The question the Supreme Court's asking, the question they're going to answer is whether, and if so, to what extent does a former president enjoy presidential immunity from criminal prosecution for conduct alleged to involve official acts during his tenure in office. Now, like he said, the way it's worded is kind of weird. So you could look at it as this is a positive or a negative. It depends on how they roll, right? But it really comes down to, okay, if he's a former president, is he still immune from criminal prosecution for official acts? Well, the answer to that is probably no. Right? He is probably immune. So if I do official act as a president, and as part of my job as president, I can't be criminally charged for that later. But if it was something that wasn't a part of it, the problem is that they put in prosecution for alleged to involve official acts. Well, in that case, any act I can allege is an official act. Right? I can allege anything. So that's his point, is if you're putting that word in alleged to involve official acts, well, Trump could say, hey, the insurrection was an official act. Hey, I killed that guy. It was an official act. Hey, I raped that woman. It was an official act. You could say that, and now it's an alleged official act, so am I immune? Well, I still think the answer to that one has to be no. It's just because it's alleged to be official doesn't make you immune. If it is official, if we can establish that it was official, sure, you should have some immunity. But I that's just my personal opinion on that. You guys can go whichever way you want to go. But Lawrence makes a good point. And we're going to get a little bit more into him, but that's kind of the question here. So this has a positive or a negative. It kind of depends on what happens. But we're going to go back to the Tribe real quick.
if they really had any interest in expedition, any interest in satisfying the public need to get this trial going and to have a verdict one way or the other before the election, they would have asked a narrower question. They would have simply asked whether a president charged with criminally seeking to remain in office beyond the end of his term has absolute immunity from prosecution for crimes committed in that vein. That would have been the right question to ask, and it could only have had one answer. This question is so sweeping that there are a lot of ways of answering it. Yes, the president might have some degree of immunity for some official acts, but that is not the real issue. John Roberts long ago said that if a case doesn't require you to address a particular question, then as a federal judicial official, you shouldn't answer that question. You shouldn't reach out. By reaching out in this way, the court has guaranteed not only that there would be this bizarre delay, they could have taken this issue before them back in last December, not only that there'd be that delay, but now the delay until late April before hearing the case. There's no reason to have that several month delay. In the Bush v. Gore case, everything moved 10 times as fast. This is a much simpler matter. It could have been resolved quite quickly. And the really weird thing is that essentially everyone knows where the story has to end. It cannot be the case that when a president is in office and tries to remain in office after losing an election and commits the crimes that are involved in that, that he is forever immune from prosecution. Yet that...
And he's absolutely right. There's just no way you can spin it that that's the case, because if they come back in June and they say, well, yeah, I mean, you are immune as a former president from anything you allege, well, at that point, why doesn't Biden then just have Trump killed? Boom, done, easy, he wins. He's immune. It was an official act as president. He alleges it. See, it's such a big mess when you get down to it, right? So he's right. There's really only one answer that can be there. And they could have taken this up back in December. You know, and they could be doing this quicker. I mean, they did Bush v. Gore a lot quicker. I mean, when it came to Colorado trying to take Trump off the ballot, right? Disqualification under the 14th Amendment. They were lickety-split on that. They had that done in a matter of weeks. This is now we got to wait till the end of April. So he's right. They've basically given him a bit of a leeway, but it doesn't really prevent anything, because it still comes to the fact that Chutkan can move this quick, and then he'll be in trial, and he could still be convicted in the state of New York prior to that, and there's nothing that stops Eileen Cannon from going forward at any point from now until then. Not that she necessarily will. She's a pretty big Trump supporter herself, so we'll see, but she's been in a lot of trouble lately, so we'll see what she does. But anyway, those are the kind of the general arguments. Is the one side is they did it, it's a delay, it's a broad question that's kind of stupid, and you could give it to him or not give it to him, but if you do, you're opening a bigger can of worms. So Lawrence Tribe's right, you really can't come to that conclusion. On the other side of the coin, you could look at it as this, and other people have looked at it this way, which is the way it's worded, they can sit there and go, okay, well, no, a former president is not immune from alleged acts, right? Or alleged official acts. They could be immune from official acts or not, but what this does is it basically hammers home in the cases going forward, especially in Eileen Cannon's case, it puts her under a bind of she's got to act pretty quick. Because if that's the case, then he definitely was not he wasn't the president, he was a former president, and he wasn't in office at the time he did this. So now she's really in a corner, because even though the question doesn't directly handle that, they've made it very clear that while he was in office, if it's just alleged, then no, he doesn't get it. But if he's out of office and committing crimes, then he definitely doesn't get it. On top of that, it strengthens this position for Jack Smith going forward in the other case. Now, you could argue that. I don't know. Excuse me. I don't know how true that really is, but those are kind of the two things. So just so you have a concept of it, it's going to delay it. It looks like he probably will be in court, barring any sort of problems in D.C., starting September, probably through October, and hopefully they wrap it up before the election, but maybe they do, maybe they don't. The New York case, on the other hand, starts March 25th. That looks pretty set in stone, barring some huge thing. And they're going to rule on the Georgia case pretty soon. So, I mean, he's got a ton of indictments coming up. But I just wanted to kind of jump on that and kind of give you the different sorts of the positives and the negatives here of what's going on with that and how it might affect the election going forward. So I hope that was helpful. If you have any questions or anything, you can always feel free to email us at gossipfinance@outlook, gossipfinancead, at outlook.com. Thanks for watching, and we'll see you next time.